morning, everyone, and thank you for joining so early on a Friday at 8:45. I hope you're not that little because you were just afraid of the title of the session. There is not a threat to see you in court, but we're really happy to see you here at the CPDP. My name is Romain Robert. I'm Program Director of NOYB, organizing this panel this morning. As the title might not be revealing too much, See You in Court is going to be a discussion about class action, and we will see that maybe it's not the appropriate term, and the Collective Redress Directive that has been adopted 2 years ago by the EU legislator. I will quickly introduce you, if I just recover my voice, and I guess you were at the Mozilla party yesterday, so you will just apologize for the voice that I have this morning. Let me introduce you to our wonderful experts that are gonna give us their expertise on this very interesting subject. You will understand why NOYB is organizing this discussion this morning. We will be totally involved in this discussion. As you may have heard, the directive should be implemented next month. You will see that things are not that easy and that simple. I will first, on my extreme left, introduce Augusta Maciuleviciute. I will never say it, Augusta, sorry, and we've been working together for 2 years. Maciuleviciute, which is almost correct, apparently. I have a 9. Augusta works on consumer protection since many years, and for the last decade, leads the consumer enforcement and redress team at BEUC, the European Consumer Organization that I guess you heard about, and focus in particular on consumer redress, and has closely followed the negotiations and the adoption of the EU directive on representative redress that we're going to discuss this morning. Petra Leupold is a lawyer at the WKI, the Verein voor Consumenteninformation, an expert in the field of collective redress, consumer litigations with 10 years of experience, strategic litigation via representative actions, and in collective enforcement via class actions. She made numerous publications on consumer law issues, and European private law and cross-border litigation. Petra is also a board member of NOYB, and chief editor of the Austrian Journal of Consumer Law, and a lecturer for consumer law at several universities. So I think Petra is kind of an experience in consumer law, as you could understand. On my right, and sorry if I have to read your very impressive bio. On my extreme right, Jurjen Lemstra is a co-founder of Lemstra van der Korst, and which is a law firm, just to make it sure, and specialize in advising and litigating corporate dispute, but also financial law case. Jurjen co-heads the firm's class action practice and advice on collective settlement, the VAMCA law. I guess you already heard about the VAMCA, the massa claim law in the Netherlands, and proceeds regarding collective action claims. And last but not least, Stefaan Voet is a professor of law at the KU Leuven and is also a practicing lawyer. Fields of research are expertise in civil procedure, dispute resolution, and complex litigation, and consumer alternative dispute resolution. So you will understand that we have really wonderful and interesting panelists to discuss the collective redress in the EU today and this morning. But without further ado, I would like to first ask a question to trying to set the scene to Stefaan, maybe to explain briefly to the audience, which is also maybe not totally caffeine this morning, what is this Collective Redress Directive about, actually?
Well, I think in the beginning, it's important to use the right terminology, because when one looks at the debate regarding class actions and collective redress, a lot of terms are being used, and also there's a lot of confusion: mass actions, group actions, representative actions. First of all, I think what we will mainly talk about are representative actions. And what is a representative action? A representative action is an action that is brought by a representative a person or an entity that is representing a group of people, a group of consumers that you cannot identify at the outset. You also don't know how many people that are at the outset. And that representative is bringing a claim, is initiating a procedure on behalf of that group of people. And that group of people is also bound by the outcome of that procedure without these group members becoming formally a party to the proceedings. In the European orbit, this is quite strange in the sense that we are familiar with procedures and judicial decisions that are only binding on people who are party to the proceedings. But the difference with representative actions or class actions, as they are called in common law systems, is that a representative is initiating a claim on behalf of a group of consumers, a group of shareholders, etc. So I think it's important to distinguish that technique from other techniques, for example, joinder techniques. For example, in Germany, in the Deutsche Telekom case, you had thousands of individual procedures, and then you have a system in place that kind of joins up all of these individual procedures. The term collective redress is a little bit confusing, in my opinion, and I remember a discussion many, many years ago with somebody from the European Commission, I think it's maybe 15, 20 years ago, and they explained that they wanted to do something to enforce the rights of consumers, and they talked about class actions and representative actions, but on the title of the document it said collective redress, and I actually said, why do you talk about collective redress? Why don't you talk about class actions or representative actions? And I remember the guy smiled at me and he said, well, the marketing people didn't think it was really a very good idea, because when you use the term class actions, it has a very negative connotation. It resembles to US class actions. So that's why we came up with collective redress. But in my opinion, collective redress is the result, the outcome of a representative action. It offers redress in a collective way. And there are also other techniques that can do that. So, but to set the stage, and I think it's important to underline that we will talk about these representative actions, class actions, in the way that I have just briefly described.
Thank you, Stefaan. It's important as well, because we see a lot of terms like, which may be confusing: class action, representative action, mass action, collective action. Is always the same thing with different text, right? Thank you very much. Maybe, Augusta, you can just explain, what can I do with this text? Is it something that is going to be useful, especially for civil society and consumer protection? How can I use this text to launch and file a proceeding? Which kind of legislation can I bring? Everything, or like, is it limited in scope in the future?
Yes. So the Directive on Representative Actions applies to the scope that is defined in its annex. And the annex contains a list of the EU legislation that, of course, has been transposed into the national law if we speak about the directives. So the Directive on Representative Actions is, let's say, limited to that scope, and it is mainly consumer legislation, even if in a very broad sense, because the directive understands consumer also as a passenger, patient, data subject, investor. So it contains a lot of pieces of EU legislation in these various sectors. But what is important to say that member states can extend the scope on the national level, either now when they are transposing the directive or at any time later. And what we know, for instance, from pre-existing representative actions in various member states, is that mostly they were not restricted to certain pieces of legislation or even to consumer protection area. The best example, I think, is Portugal, that has, they call it a popular action, that has representative procedures since 1994, And there they can apply them horizontally to any sector where there has been mass harm situation. So labor law, environment, discrimination cases, but also in other countries we have a wider scope in the pre-existing procedures. So I hope that we will also see that member states extend the scope when they, transpose the directive, which again, as Romain has rightly noticed, most of the member states are late to do. What is also important that the scope will be constantly extended on the EU level, because already since the adoption of the directive 2 years ago, Digital Services Act and Digital Markets Act were added to the annex, and there are several pending pieces of the EU legislation where there are provisions to include them under the scope of the directive.
Thank you, Augusta. And I think it's an interesting point that the DMA and the DSA are in the annex, because there is the Commission is supposed to be the gatekeeper to enforce the text, but maybe everyone forgot that the text was also in the annex of the directive. So we're going to see what's going to be the outcome of it. But Petra, you had a comment on.
Yeah, thank you very much. First of all, thanks for having me. I'm very happy to contribute to this panel. And I just wanted to start adding and emphasizing that the Representative Actions Directive, from a practical point of view, as well as from a consumer policy perspective, is an absolutely central piece of legislation, because it brings exactly compensation into the equation. And I'm convinced that it will help close the justice gap, which has been identified across Europe, also as we heard yesterday on the enforcement panel when it comes to public enforcement, right? Concerning data protection and privacy rights in particular, the directive is a possible game changer, as Augusta also pointed out, exactly because unlike the Injunctions Directive, so the predecessor directive, the Representative Actions Directive applies to GDPR violations now, and in addition not only provides for injunctive relief but also for redress actions. And this means that, for example, NOYB, as well as consumer organizations like VKI, or in Germany VZBV, which is very active here, which are already seasoned and experienced in collective litigation in the field of consumer law, now actually can engage in meaningful litigation in the private enforcement field and target GDPR violations, which we couldn't do so far. As to the regulatory approach, and Stefaan already pointed that out, I see three key benefits of this concept and the mechanism of the Representative Actions Directive. First of all,
If I may, Petra, we didn't mention what can you ask with this directive. We didn't mention what can you ask with this directive. It's true, like what can you claim it's.
So first of all, representative actions, at least in Germany and Austria, have a long-standing tradition and have already proven to be a highly effective tool when it comes to, and this is exactly the question, when it comes to preventing future violations via injunctive orders. So you can seek redress, not just redress, but also injunctive orders. And this function of a representative action seeking to prevent future violations of the GDPR means a very important complementing function to public enforcement via the DPAs, of course. Secondly, it also means that we have a highly useful instrument for the purpose of strategic litigation in the realm of data protection now, because representative actions qualify, as we have already seen through the VZBV and VKI injunctive actions so far, they qualify as a fast-track tool to refer legal issues as regards the construction, the interpretation of the GDPR to the European Court of Justice for clarification, so in order to get legal certainty on how to construe the GDPR, which is beneficial, of course, for all involved parties, right? Really important. And finally, and this is the last point, redress actions, of course, and this is in focus so much, but it's only one of the functions of representative actions. There are redress actions, right? So there are actions seeking redress for data subjects. So representative actions are a potentially appropriate instrument for mass enforcement. Though, and there are two caveats, and I think we will talk about this in more detail, its effectiveness when it comes to actual enforcement, so redress, heavily depends on how to construe especially Article 82 with respect to compensation claims for non-material damages, and whether unjust enrichment claims, for example, can be argued under national law. And we will talk about the post case, I think, and its implications later. And on the other hand, and equally important, Augusta mentioned this, as to the effectiveness of representative actions as a redress tool, it's up to the policy choices of the member states concerning the implementation of this directive into their procedural framework. So there are a lot of policy decisions, and the effectiveness of this tool will depend on that heavily.
Thank you, Petra. So basically we can see we have like two main requests, I would say, claims that you can do under the directive, and depending on member states, cease and desist and or damages, and we will see that damages is an open question, of course. Good news, civil society consumer organizations like NOYB and other consumer organizations will be able to litigate under the directive, very good news. But maybe, Stefaan, you can just briefly say something that was usually ignored about another avenue for resolving a claim, which is the settlement. We love American law firm theories on the television when you see we want to settle. And maybe we could do that in the EU as well. Like, how can it work?
Well, I think the situation in Europe is a bit different than in the US. In the US, most class actions, when they are certified, which means when they are declared admissible, are settled because for both parties and mainly for defendants, it's too expensive to continue litigation, for example, because of discovery. In Europe, the European policymakers have said, okay, EU member states, you can have these representative actions, but what we actually want you to do is incentivize collective settlements. And in most jurisdictions that already have class action mechanisms or are in the phase of implementing them in light of the directive, for example, the Belgian class action regime, which is not very successful if you look at the number of cases, but from a procedural point of view, it allows for the parties, so the representative, as I discussed previously, and the defendant to have a settlement at any stage of the proceedings. Even more, when the action is declared admissible, there is a mandatory negotiation phase. And the best example, and the man to my right will probably, Jurjen will be able to say more about that, is the Dutch model, the Dutch model that exists since 2005, the Dutch Collective Settlements Act, which allowed for these collective settlements to be concluded between the parties and then approved by the judge. Now, again, from a procedural point of view, for a judge, that's not so easy, because usually when a judge is confronted with a settlement, the judge will be very happy, say, okay, I will approve the settlement, go away, the case is finished. But in class actions and representative actions, this is different, because the settlement deals with the rights of consumers, of class members who are not in the courtroom. And the lawyers for the plaintiff and the lawyers for the defendant, they are holding hands, they are kissing each other, and they are asking the judge, please approve our settlement. But then the judge has the difficult task of seeing, first of all, whether the settlement is in the best interests of the class members, and also the second aspect, and I have to pay attention because there's a lawyer next to me, the lawyer's fees also that are part of that settlement. So we will have to wait and see, but what the bottom line is, and the directive explicitly pays attention attention to these collective settlements and the fact that the judge has to look at the terms, has to look at the content of the settlement, whether this is in the best interest. These representative actions can, and I think will be, a very important trigger for collective settlements. And I think actually this is maybe one of the good outcomes also for defendants. We're talking here only about consumers, but also for defendants who want to get rid of the case, who want to have finality, closure, and the best way to do that is via collective settlements.
Thank you, Stefaan. And good news as well that Belgium is one of the only member states when a non-Belgian entity could qualify as a qualified entity in Belgium. And I'm happy to announce that NOYB is a qualified entity in Belgium and is ready to litigate under the collective redress regime in Belgium from day one. And talking about qualification, Jurjen, maybe you can walk us through these two lists of the directive, and maybe the first one, which is the domestic list of qualified entity, and maybe Petra will explain what is this other list of the cross-border litigation. You will maybe understand that it's there is a twofold approach by the directive in this regard, and maybe just explain what is this domestic list about, and how can you become a qualified entity under this list?
So first of all, am I audible? Yeah. First of all, just one short reaction as a lawyer to the previous remark by Stefaan on the settlement, let's say, mechanisms under, for instance, the Dutch Settlement Act. The problem is not so much the fees of the lawyers there for a judge, but it's more the fees of the funder, because lawyers are not obliged to ask for contingency fees, so they are just paid by the hour, which is a nice fee, but it's not important in the light of a settlement of that order. But the funders, external funders, they are now claiming between 20 and 25% of the eventual outcome of the settlement. So that is, I think, the biggest concern. So I feel a little bit more comfortable sitting next to you. Going back to your question, Romain, about the system in the directive of what they call designated entities. So it's not up to you or to us to start representative actions. You should be a designated entity according to the directive, and you should follow a certain set of rules. And for domestic purposes, it is said that the authorities, the national authorities, have to come up with a list where you can find the designated entities that are authorized to bring a representative action in the specific member states. And what are the requirements in general? Just very shortly, it should be an entity that has been there for at least 12 months in the public domain, whatever that may be exactly, but there should be a certain history of the entity that brings an action. And again, there will be exceptions according to the member states, but that's the general rule according to the directive. Another one is that the entity should not aim for profits. So it should be an entity that represents the interests of consumers and not its own interests. It shouldn't be obviously insolvent or being involved in insolvency procedures. And there shouldn't be involved persons, third persons, that have other interests than the interest of the consumers that the entity is representing. So let's say funders or other people that are, let's say, connected to the entity that have their own interests that may conflict with the end goal being safeguarding the interests of the consumers. So
you mean basically that Google cannot fund a class action against Apple?
Exactly. That's also, yeah, that's also something. That's another rule. If a funder, for instance, is also involved, it cannot start actions against a competitor or against a company where there are some independent connections or dependent connections. I mean, that's also a topic. So the whole concept of independency and let's say the focus on the real interests of consumers, because there is a lot of commercial appetite in this market to bring actions. And I think the lawmakers were a little bit afraid and concerned about what you called American situations. And that's always a little bit the reflex when it comes to European legislation. We try to stay away from what is perceived as negative, but in my view can also be quite positive, but that's another story. There should be a public website where you can find that the specific designated entity complies with all the rules. I think that's in general the system. You can look at that list. So if you want to check whether a public entity or whether an entity is authorized to bring an action, you can just look at that list. And then there is also another list we will talk about. Maybe Petra will do, I don't know. But just one other final remark to echo also Petra's comments that under the directive, actions against, let's say, the big techs become very relevant. And it was already relevant under the GDPR, but this connection between GDPR and the directive makes it that the big techs are more exposed to, to actions where there is a violation of privacy rights in place. For instance, in my home country, there are now big cases on behalf of more than 10 million Dutch citizens against Facebook, TikTok, and since this week also against Google. And that's on an opt-out basis, a representative action which is on behalf of the whole Dutch class which used the Google device or Facebook. And they can choose at a later stage to opt out, and that's something we can talk about later on. But it shows the relevance of this whole debate today.
Thank you very much, Jurjen. And it's interesting to understand it was a national list, depending on the criteria adopted by the member states, which may lead to some problems. But there was another list, Petra, which is the cross-border list. Yeah. Maybe you can explain what is it about, and is it like a better solution?
Maybe just a quick comment on what you said, Jurjen. I think what we see, and you mentioned this in Article 4, it reflects this deep distrust of the European legislator with regard to American class actions and collective redress in the field of data protection law as well. And I think it's quite, I would be quite critical of that because we just do not see any precedent of abusive litigation when it comes to consumer litigation. And we rather see the problem at the other end of the spectrum, that we have kind of a bottleneck issue. Legal standing is limited to not-for-profit organizations. So we have we have altruism, right, and we have resources issues. So I highly doubt that under the Representative Actions Directive, there will be, like on a large scale, collective actions in every case where we should have litigation for overall consumer and user welfare and benefit across Europe. So I'm worried about the other end of the spectrum, the bottleneck issue. One last point I wanted to add regarding the scope of Article 4. This list of threshold criteria when it comes to legal standing to bring cross-border actions. These threshold criteria only concern actually cross-border actions, and this term refers to representative actions brought by a qualified entity in a member state other than the state of its designation. So all other actions, including those brought against defendants, traders, controllers from other member state or against non-EU players especially, as well as actions which represent or try to represent and include consumers not resident in the actual forum state, for example, seeking union-wide redress especially, concern domestic actions in the terminology of the Representative Actions Directive. However, this will often, like from a consumer organization's point of view, this will of course often actually concern the main focus of interest and activity on the part of qualified entities, because it's a huge resources issue, whether you take up litigating in a forum.
And about Petra, maybe about this international list?
Well, it's also, you just need to qualify for the threshold criteria. Jurjen just mentioned this, like public activity, a track record in the field of consumer law activities, legitimate interests, not insolvency, and then you kind of register in the list with the European Commission. And what is important is that legal standing needs to be recognized in all member states. So once you're in the list, you can sue in any member state, right? If you have, of course, jurisdiction to do so, which is another issue.
Interesting, interesting. So 2 lists, one allowing you to navigate and to travel in the member states to issue litigation wherever you want. That's a novelty for collective redress. Thank you very much.
Yeah. Yes, maybe just one final remark about the efficiency of the whole system. And that is about, I think, if you have an opt-out system where you're not required to get people signing up for your action, it's obviously more efficient to start an action, apart from the funding issues and funding problems. But for instance, in the Netherlands, we were trying to get an opt-out system for all across Europe, and that was not, I think, within the spirit of the European legislator. So an opt-out system is a system where you, as a qualified entity, you just start an action on behalf of all the Facebook users without asking your consent. So you are in the class without being asked to be in that class. So you are in it and people are fighting for you in court. And at a certain point of time, you can opt out if you are not satisfied with that specific action. You can write a letter and say, listen, I'm in that class, I don't want to be there, I want to pursue my own interests, or I don't want to have anything to do with it, and then you can opt out. But if you are silent, if you remain silent, then you are in the class. So that's a very efficient system in order to put pressure on big defendants. So you can say, I'm acting as a legal entity, as a designated entity on behalf of all the citizens of one member state. What is not allowed under European law as it stands today is to extend that system to foreign member state consumers. There you have to apply a opt-in system, which means that if you want to litigate, for instance, in my home country, in the Netherlands, against Google on behalf of all Dutch Google users, then it's based on opt-out. But if you want to expand it to Germany and Belgium, you have to start a opt-in system and ask Belgian citizens and German citizens to just opt in with the legal entity and to confirm that they want to be part of that class.
Thank you, Jurjen. I'm going to say that it's a crucial discussion when you want to find a funder, opt-in, opt-out. We have to go a little bit through the script, so I would just maybe skip 1 or 2 questions just to leave some question and answer for the audience. But maybe it would be interesting to hear from you, Stefaan, what is the state of play, and we understood that it was not really a good situation right now, of the implementation of this directive, which was supposed to be implemented by 25th of June, right, of next month.
You know, it's the 22nd of December of last year.
Yeah.
That was the deadline. So 22nd of December 22, the directive had to be implemented. I think at that stage, only 4 or 5 countries did their homework. The other countries received a very angry letter from the European Commission saying, you have to do your homework. I checked yesterday, and if you look on the website, there are now, I think, 10 or 12 countries that are in the phase of having implementation measures. But if you look at the discussions, it's very interesting to see that. I think in the number of countries that already have quite well-established regimes, for example, in the Netherlands, for example, in Belgium, for example, in Western European countries, there the implementation process runs quite smoothly. The problem you see mainly is in Eastern European countries, Southern European countries that have no class action regimes at all. And they are really sometimes struggling to implement that because, and I think it's very important to underline that, I mean, the Representative Actions Directive has a sort of model, a procedural model. But if you implement that, there are also other things that come into play, and we have already heard some of them. For for example, the funding issue. How do you fund and finance these actions? What about cross-border cases, the applicability of the Brussels 1bis regime? And a third aspect, and I was involved in a number of discussions with Eastern European countries, and what is crucial in this whole system is the role of the judge. The case management tools of a judge is crucial. And I remember a discussion regarding opt-in, opt-out. Most countries, and in my opinion, this is the best way to do that, is they leave it up to the judge. Although I agree with Jurjen that, a real class action will only work in an opt-out regime. In some countries, for example, I think it was the Czech Republic, if I'm not mistaken, the government came up and said, okay, the judge has to decide between opt-in, opt-out, but the judges freaked out. And they said, we cannot decide it. We need to know how many class members there have to be for opt-in. For example, if there are more than 100, then it's opt-in, because we don't have these tools. And this anecdote illustrates the difficult mindset and sometimes the difficult legal culture in which this instrument will be embedded. And I see in the implementation process that, implementing the directive is as such not so difficult, but it is the legal culture and also the rules, for example, for lawyers, ethical rules, funding rules. All of these issues, that is really, I think, a lot of countries, a lot of member states, I think are struggling with that. And events like this, I think, can clarify a lot of things.
Thank you, Stefaan. So we're not there yet with the directive. We had a beautiful script to follow, I know it, but time-wise, we have to maybe skip some beautiful and wonderful stories that I wanted to hear from you. But we have to address two elephants in the room. You're not the elephants, but the two elephants just are related to money. The first one that we want to address is concerning the money funding the litigation, and you will see that the other one is the money that you can just expect from the litigation. So the first elephant is the room. We have a nice directive, Augusta. We have a nice civil society and consumer organization ready to litigate, hopefully being qualified. Sorry for my mic. But then, and we were talking about lawyers' fees, and Jurjen, we worked together from a litigation last year in the Netherlands, so you're still very competent, of course, but you're not for free. How can you pay your lawyers when it's usually huge litigation with huge class to manage, where the money can come from? Is it a problem? Is it an obstacle?
Indeed. That is one of the biggest obstacles, because as you would have noticed, the directive requires that these qualified entities are non-for-profit. And if you are a non-for-profit consumer association, you usually do not have big resources. But it depends on the country, but in most countries, you don't have huge resources to be able to pursue a litigation that usually lasts years. Because the defendants, they use every trick in the book to prolong the litigation. They appeal every step of the procedure, they delay, and of course, expecting to run you out of your money. So the financing question is the crucial question, and as an umbrella organization for national European consumer organizations, we advocate for as many financing sources to be available as possible, including commercial third-party funding, which is for some reason similar, to class actions. Also, I would say, has a very negative connotation in the sense that it abuses, the individuals, because then the individuals usually cannot receive the full compensation because part of it goes to pay to the funder. But if without that kind of funding there would be no action whatsoever, it's still much better to receive, let's say, 75% of your compensation than zero. So we are, of course, in favor of the third-party funding being available, and not only it allows to bring cases, but it also gives the equality of arms with the defendant, which are usually huge companies, and there is this imbalance of of a consumer association against a very big company. So when you have the third-party funder behind you and the defendant knows that you have enough money, this gives you, as I said, equality of arms and maybe bigger chances of a settlement as well, because they know that you can pursue the litigation to the end, which is very important.
Thank you. It's an important question, of course, the money. And Petra, you have experience finding the money, of course, to negotiate with this funder, third-party funder, private companies, right? What do you think would be the most important points to think about when you enter into negotiation with these companies? You don't have to reveal your secrets.
Yeah. No, I just want to stress that I absolutely concur with Augusta's points, because from our practical experiences on the ground, proper financing of mass claims is one of the, if not the key condition of their success, because it's exactly insufficient funding and this chronic lack of resources on the part of consumer organizations, which are the major obstacles to enforcement. Also, the status quo, and you pointed that out, is that from an Austrian perspective, third-party funding has been and continues to be an essential part of each and every Austrian style, so-called Austrian style class action, exactly because not-for-profit organizations like VKI, also NOYB, of course, they cannot bear the cost risk, right? So the provisions on financing, and Augusta mentioned this concern, actually a major flaw of the directive. Article 20 suggests public funding and the reduction of court fees, which is kind of half-hearted and won't suffice to make sure that those actions are actually happening. We're especially worried about Article 10 of the directive, that it could have like potentially negative implications for third-party funding. Because especially also the provision, like the construction of the provision is all but clear. And I would like to address two more points briefly, because there are a lot of like negotiations and proposals and discussions going on at EU level currently with regard to third-party funding. So whether it's permitted or not under the directive is for the national legislator to decide, which is, by the way, a very important point with regard to forum shopping, because the Lex Fori, so the procedural law of the forum state probably will determine whether third-party funding is allowed or not, and which is absolutely crucial, of course, for those actions. I just wanted to address one point that is usually brought forward and argued against third-party funding. So there is the argument of putting consumer interests first, and which is always like kind of a little bit cynical, because it's true that the fee for third-party funding is, of course, deducted from the overall amount paid by the defendant in case of a settlement or affirmative ruling, and we heard 20–25%, depends on which stage of the proceeding you're in, might be also up to 35%, right, if the third-party funder actually bears a lot of cost risk. Still, as of now, I mean, it's low compensation before no compensation. And Augusta mentioned this. Of course, consumers should be compensated in full, but we're not talking about this ideal brave new world where consumers actually have a choice between getting compensated 100% or 70%. In the current world we're living in, we're talking about the choice between getting 70% of your damages or zero, right? So that's actually why we consider third-party funding a crucial aspect and a very important cooperation on the part of consumers' organizations. So in light of our experiences, we're more worried about the wrong kind of regulation when it comes to third-party funding and its potential impact, detrimental impact on collective redress than of conflicts of interest, excessive remuneration, which are topics that are commonly, and in my opinion wrongly, referred to when talking about an unregulated market.
Thank you, Petra. And I'm trying to be a good timekeeper, so we will just maybe jump directly to the other elephant in the room. But I was just wondering, if not third-party litigation, and just imagine you're in a member state when third-party litigation is funders, are not allowed. Do you have an alternative to fund your litigation? What would be the other options?
Well, I think, and I agree with what Augusta said, I think it's wrong to put all the eggs in the same basket. I think it's important to focus on different funding options. I agree with my colleagues in the sense that third-party litigation funding, I think, is crucial. And I also am a little bit worried about the some legislative developments on the EU level. Maybe to put it bluntly, as you know, I mean, class actions, it's something very controversial. You have proponents and opponents. It's not difficult to know who the opponents are. And they first maybe try to kill the system via lobbying. Ultimately, now we have the Representative Actions Directive, but what you now see behind the screens is that they are trying to kill the funding issue, and they're trying to have legislation in place to regulate private funding, which I think would not be a good idea, because I have not seen any hard empirical evidence of abuses. On the contrary, if you have as a qualified entity a funder behind you, the funder will only invest in litigation that the funder thinks is worth doing that. There's a due process system in place. If I am a defendant and I see that the plaintiff has a funder who backs him, then I think, oh, this is a serious case, because otherwise the funder will not do that. Also, the remuneration of the funders is much more nuanced than, I mean, some people think. So I think this is crucial, but other options, I mean, I do not think that, legal aid will help. Legal expenses insurance will also be difficult. There's some case law of the Court of Justice that makes it difficult, the Eschich decision. Another option, again in the Netherlands, what they are talking about now is to have a sort of public fund that exists, for example, in Quebec, that also exists in Israel. It's a sort of public class action fund. If you, in the beginning, money is being put in that fund by the government, but then if you get an allowance, if you get funding via that fund and you win the case, you have to pay back a part of that money to that fund. So it's actually self-sufficient. There's a study that was already been prepared in the Netherlands. It's not public yet. So I think this is an issue. What also can help then is, and maybe this is a little bit more technical, it's called a Cypre technique. So if at the end there is a collective settlement or a decision on the merits of the case, and the defendant has to pay, let's say, 10 million euros, then that money has to be distributed among these class members. It's a very difficult thing. If at the end not all class members come forward to claim their money, and for example, there is a residue, let's say, of 2 or 3 million euros, what do you do with that? You give it back to the defendant, or you do something else with that? And what happens in a number of countries is that money is being used, for example, to put in a fund to fund and finance future litigation. But I think, the most, healthy approach, I think is basically to look at all. Another issue that was also mentioned is what is called one-way cost shifting. If a consumer organization is bringing, and you can de facto consider it a bit of a sort of public action, loses the case, then that representative, that qualified entity is exempted of, for example, paying the court fees. So there are a lot of options, and I think it's important not to focus on one or two, but really to focus on everything and make sure that these procedures are viable also from an economic and financial point of view.
Thank you, Stefaan. It's interesting as well.
May I just add to my colleague, thank you for your explanation. I also see one last possibility in really huge class actions or representative actions, and that is asking a small contribution from the people. And that was the system like 10 or 20 years ago. You would ask 10 or 20 euros from each individual consumer, and that might add up to millions for your budget. That is not common anymore, but that used to be the system before the funding market started to emerge.
One quick comment. From our experiences in Austria, yes, this is nice to have, but this is not sufficient to actually, depends on the cost structure of the procedural framework, right? But for Austria and Germany, financing litigating through contributions by data subjects or consumers is never, ever going to make it fly. So.
Very briefly, even though I see, Romain, that, that you want to progress, usually it's not so difficult to find, for example, third-party funding for huge cases, because that's what the funders are interested in. What is difficult is to find the financing for smaller cases that could be as strategical as the big cases. But if the aggregate value of the case is not big enough, the funders are typically not interested. So that's where also the big gap lies. So that's why I also say that, we are trying to find and to make sure that as many of the financing sources as possible are available. Because it's not the response that if a country would say, look, I allow third-party funding and no, go and bring cases. It will not be available for all kinds of cases or even in all countries. In smaller countries that have opt-in systems, it will typically be extremely difficult even to find a third-party funder that is willing to fund your case because the pot will simply be too small. Thank you.
We have now 7 minutes to address the last and second elephant in the room about money. Of course, we saw that the directives allowed us to ask for cease and desist, to stop a practice, or to ask for damages, compensation. So if you bought a car, it's easy to be reimbursed of the price of the car, right? But when we talk about GDPR, DMA, DSA, all your digital rights being violated, what can you claim actually? What is the damage that you can claim? And we just saw that the damage was basically the basis for the funder to know how much they could obtain from the litigation, right? So Petra, you can maybe explain why is this damage thing so relevant, especially in digital rights? And obviously maybe just explain how the last development of the case law of the Court of Justice might help us to see some clarity in this discussion. And I'm sorry, I want to point out the time. Sorry about that, but we have like 6 minutes to go through that.
I'll keep it really short. Thank you for the question. This is a really important development with regard to, which has actually very important implications for the effectiveness of collective redress in the field of data protection law, which is the question, what are the prerequisites for non-material damages and compensation claims under Article 82? And we have a decision, a judgment of the European Court of Justice now in a post case where the court rejected the notion of a de minimis or a gravity threshold, and especially, and I'm very happy about that, did not follow the Advocate General's opinion, which was rather unfortunate doctrinally and especially also from a consumer protection point of view, actually. So the interpretation of Article 82 and especially prerequisites of claims for compensation of non-material damages are of significant importance with respect to feasibility and effectiveness of private enforcement under the GDPR, exactly because, of course, evidently, most GDPR violations do not have any tangible financial consequences. They do not cause any material damage on the part of data subjects. So this means if it weren't for the compensation of non-material damages, GDPR violations basically would not have any liability consequences at all, which of course goes against the very rationale of Article 82. So it is, in my opinion, very important that the court now issued this judgment and rejected this introduction of a minimum threshold under national law, because we have seen pervasive hesitance actually on the part of courts, especially in Germany and Austria before, to award non-material damages. So this ruling is important. With regard to, and just one more remark, why this is so important, with regard to collective redress and representative actions, is that, of course, the effectiveness of redress actions, especially when it comes to multi-state redress actions or union-wide redress action, highly depend on the degree of harmonization provided for by the GDPR. So the application of multiple laws, right? So the more individualized it is, the less likely that we will see a lot of those redress actions. Because if those claims are individualized in terms of proof of causation and existence of damages, it is very hard to launch collective enforcement actions. And why is that? Because, I mean, cross-examining each and every data subject on the question of causation, for example, or existence of damages, does not render collective actions under the RAD regime legally inadmissible, but of course it's a resources issue again. Like it would make them pretty much unfeasible because courts and resources it takes on the part of plaintiff organizations, but also on the part of the courts, would just be excessive, right? So this is why it's very important that the threshold was rejected by the court, and we will have to wait and see how the principle of effectiveness now is applied in order to safeguard this very important right to compensation as regards non-material damages.
Interesting. So we might have big fines on the DPA enforcement on the one side and huge damages on the other side. We will see. There are currently, I think, 11 pending cases at the Court of Justice regarding the immaterial damages. And I think Jurjen will discuss to prepare this call about an opinion of the Advocate General. Maybe you had the time to go through it and explain. There was a recent opinion of the Advocate General in another case that might even be more, let's say, interesting in terms of damages. And maybe sharing your experience in the Netherlands with damages as well.
Yeah, well, I think the court decision that Petra referred to was dated 4th of May, and the opinion of the Advocate General that you are referring to was of the 27th of April. So,
no, I mean, in
but
other case.
Yeah, it's in another case. You're totally right. It's another case, and there it was the concept of whether you would be eligible for immaterial damages if you have a certain fear that you might suffer damages in the future. So the damages have not been concrete yet. And that could cause immaterial damages, a sense of fear, etc. Would that be conceptually also part of a immaterial damages discussion? And the Advocate General said, yes, in principle that's possible, but there is a but. The problem is, how can you prove it? And that will be subject to other discussions. We don't have time anymore, Romain. And about immaterial damages in my home jurisdiction, there is quite a few examples already in case law that damages are awarded for immaterial damages. I mean, in a range between 150 euros and 2,500 euros in individual cases. In class action land, there is not a decision yet, but there is one case against Oracle and Salesforce where the ticket will be 10 billion, not million, but billion. And that's because it's on behalf of 10 million people and on an average of 1,000 euros per person, and that would add up to 10 billion. So the stakes for the big techs are enormous. So I would say a nice way and a nice leverage to sit around the table and settle it rather than litigating for 10 years more.
Which is also another option, right? I think it's now time to maybe open the floor. Maybe you wanted to add some things, Augusta. Maybe to open the floor for questions. Please come forward if you have any questions. Or just maybe you will, someone will bring you the mic. Maybe you can briefly present yourself
Yes.
and
My name is Māris Rukers. I am from Latvia as a data protection expert. A short information, we in Latvia don't have any class actions exception environmental law, where everybody can go to the court. And we have until now no implementation of Consumer Directive. I have seen the project. The project provides no class action rule at the moment. But the question I want to ask is, could you please more explain this correlation between Article 80 in GDPR and this consumer class action instrument, because the reference is also to the GDPR in the Consumer Directive. So what is this difference if it is possible? Yeah. Thank you.
Yeah, thank you very much. Maybe just one quick sentence. Yeah, so actually also in Austria, with regard to implementation, we're late as well, right? So we don't have an official draft yet, so yeah, we'll have to wait and see as well. As regards Article 80 and its relation to the Representative Actions Directive, what is important is that Article 80 did not mandate member states to introduce representative actions on behalf of data subjects, and it actually prohibited to introduce collective redress mechanisms via representative actions in the realm of compensatory redress, right? So this is where the Representative Actions Directive actually adds a real value, because now it mandates the member states to introduce, also with regard to damages claims, this tool of a collective redress action that actually and directly benefits the representative consumers. I hope this answers the question.
If someone wants to add.
Maybe one, just to chime in on that, one additional element in the Article 82 of the GDPR is that the whole principle behind the GDPR is to provide for full compensation. And that notion is very important when it comes to debates on damages. So the two are linked, but this concept of full compensation might help.
Maybe, do we have another question from the audience? Maybe Madam over there.
Hi, my name is Christina. Is it working? Okay, hi. My name is Christina Bonova from Masaryk University in Czech Republic. I attended a conference on class actions last autumn, actually, in Prague. And the outcome was, because we basically have only, we have two consumer organizations, but only one is big enough to deal with this. But actually, even not this one is big enough. There is not enough resources. We already mentioned that the financing is a big problem, but not only how much will actually consumers get, or who's gonna be financing the litigation as such, but also the NGO doesn't have enough resources, doesn't have enough staff. I was wondering, was the situation maybe in your countries, if you have more organizations or enough people to actually be able to proceed with this? Thank you.
Maybe Petra.
Yeah, thank you. Also, just here, one quick remark. Yeah, this is something, maybe Augusta, you can talk about that as well. We experience, for example, with the BEUC network and mechanisms and meetings, this is the huge problem, right, of consumer organizations. The consumer organizations face, and in Austria and Germany, and I'm talking, of course, because this is where we are mainly, yeah, there is funding to a certain point from the government, but we see that in many member states, consumer organizations actually do not have the means and the resources. And I just want to add that under the Representative Actions Directive, the member states are obligated to make those actions happen. So to a certain extent, of course, there is the argument. On the other hand, we know it will take time. Yeah? So the Commission will need to take action to enforce this kind of effectiveness that's needed on the part of the European legislator. Yeah.
Yes, and we have some examples where the governments were looking at the possibility of the consumer organizations in their country to bring these actions, and even investigating in how maybe a structural state support could be provided or helpful to strengthen consumer organizations. So that's one thing. Another thing is that it's not only consumer organizations, of course. It could be also the digital rights groups, passenger organizations, patient organizations in their areas, you know, bringing these cases. But the main point, of course, that the governments are obliged to look into, you know, what will be the real possibilities on the ground for the national civil society organizations to bring these actions.
Thank you. Wonderful session. I want to ask Amit from Israel, from a legal point of view, how much new law is created through these procedures, or new interpretations of the GDPR, or possibly other consumer laws, and how much it's more like straightforward enforcement of clear law that was just not enforced by the DPAs? And are these procedures institutionally fit for this purpose? What we've seen in class actions in Israel, that the judge now needs to decide on a question which maybe have social implications and sometimes technical if it's security breaches. So is this modality, you think, effective to reach good balances between data protection and free flow of information, innovation? Thank you.
Maybe you want to add a comment?
Yeah, I think it's very important. So it doesn't add or introduce new rights to consumers or data subjects. It's just a mere enforcement procedural framework, right? A mere enforcement tool. And I don't know if you would have listened to the panel like yesterday, for example. I mean, this is something we come across in the field of public enforcement, that we just have a striking level of under-deterrence. So this two-tier system approach that GDPR has taken, and that we also see now implemented in the DMA, DSA, Digital Services Act, AIA, and Data Act, for example, has been chosen for good reason, right? Because public enforcement alone does not suffice to reach an adequate level of consumer protection, user protection. So this is where private enforcement, I think, would need to play a significant role in increasing and enhancing this level of protection.
If I may add as well, you may see that DP enforcement is sometimes super slow. I just invite you to go to NOYB website. You will see that 85% of our complaint has not been addressed yet after 4 years. Even if court can be slow as well, it's still to be seen whether the judge will not be quicker than the DPA itself. So that's another option for enforcement, I would say. But maybe you have a thought on that.
There is also a psychological notion that the fact that there is this directive, that there is the GDPR, is a clear signal also to the courts in the various member states to take it very seriously, and that there is nothing wrong about claiming, on the contrary, that there is this gap of justice and this problem with access to justice, and now it's possible also for smaller claims to be more or less represented. And that's also, you know, for the level playing field important between companies on the one hand and consumers on the other hand. So I think that that's something we could add as well, and which we as lawyers also use in the courts. We refer to the GDPR, we refer to the notion that there should be full compensation, that it should not be a too formalistic approach, but there should be a more substantive approach, etc., etc. And that you can see back now in the recent developments on immaterial damages, like we just discussed.
Thank you. Maybe another question, or maybe 5 minutes left, or maybe a case that you want to present so that we just test the next case in the class action in a few months. That's also a nice idea. Any other question? Maybe I will have one last one for our panelists, because we were mentioning a lot the GDPR and the collective representative action, and maybe it answers your question as well. It's not about only GDPR. that's interesting value of this text. It's just a lot of texts are in the annex of the directive, and litigation, usually in DPA or GDPR litigation, are only related on GDPR violation. In this case, you can see the potential of litigation. When you go, for example, against big tech, you can invoke not only the GDPR, but liability, consumer protection, and the DMA, and the DSA. And I think it's a wonderful tool to address an issue which is more complex than only usually focusing on one violation of GDPR. And I guess you may have thought on that, because it's also interesting. We're going to see a new, I guess, are we going to see, do you think, a new outcome of this litigation when the judges can, include more than the GDPR, than a full range of text and legislation?
Yeah, I think you're making a very good point, and it goes beyond the fact that, in the annex you find the GDPR, but it has to do with the scope of the directive. In the beginning, I always was very skeptical about that, because the scope of the directive is limited to consumers, and you have to find a cause of action in one of the acts that you find in the annex. If you don't have that, then you cannot use the instrument. And I made the same argument in 2014 in Belgium, where we had a similar system. I think that the European policymakers copied the Belgian system, which is never good. And it could be a constitutional problem, because for these cases, when you fall under the scope of application of the directive, you have collective access to justice for consumers who otherwise have no compensation. There is public enforcement, but public enforcement doesn't really focus on redress. But if you are somebody who falls outside of the scope, there's only individual access to justice. And I think this is, a big problem that I think will also, a discussion that we will also have with a number of member states. This idea was challenged before the Belgian Constitutional Court, in the sense that there could be a discrimination. The Belgian Constitutional Court had no idea what class actions are, and they said, oh, no, it's not a problem. In France, the Conseil Constitutionnel said the same. But I think this is a problem in the sense that when you talk about judicial lawmaking, when you have these class actions, that sometimes parties involved in these cases, but also judges, will be constrained by the strict normative framework in which they have to be operated. We will have to wait and see what will happen. Maybe lawyers, who are usually very creative, can find ways to circumvent that. There will be case law of the Court of Justice of the European Union, but it is, I think, a concern.
Thought about, is it a new era for enforcement of digital rights compared to the GDPR, for example? What do you think? Do we have to be hopeful?
Yeah, maybe just, I really concur with your point, Stefaan. I think it's highly problematic that the Representative Actions Directive is limited to a very narrow definition of consumer that actually does not fit the digital world, and also like the broader protection concept of the GDPR, for example. I just wanted to make another point. You mentioned this, Romain, before. What is very important, also with regard to jurisdictional issues under Brussels 1, is that at least consumer organizations under the RED are able to claim compensation, for example, in entirety, meaning they may also bring forward different bases for claims. So because often GDPR violations have a strong interlink and also constitute unfair commercial practices, for example, under the UCPD, the Unfair Commercial Practices Directive, or they breach consumer law with regard to contractual rights. So we often see that it's not just GDPR claims, but they can actually be based on other pieces of legislation as well. And of course, it wouldn't make any sense if you couldn't bring forward those legal basis for those claims in one action, right, with regard to the same consumers affected. So I think this is a very important point. Also with regard to the enforcement of the GDPR, that you can actually try to enforce the GDPR via, especially, for example, competition law. So this is something to consider.
Interesting. It's just 10 o'clock sharp. It's a difficult exercise to be a timekeeper for such a passionate and interesting discussion. Of course, you can just come to us if you have any other questions. Thank you very much for your contribution this morning. Thank you very much for waking up so early on a Friday and the day 3 of the CPDP. I hope to see you very soon, not in court, but at the coffee machine maybe. And have a wonderful last day at the CPDP. Thank you very much.